Good afternoon. It is Wednesday, March 21st, 2018. It's 5 p.m. and this is a meeting of the Law and Ordinance Committee. My name is John Schweizer. I'm the chairman. On my right is Mr. Todd Sievert. On my left is Mr. Phillips, and we are here to discuss the overlay district again. Mr. Titterington?
No.
Well,
No, this
BZA,
is
some
BZA.
portion of
BZA. It
it.
has nothing to do with the overlay district.
We'll start over.
Whoa, wait a minute. I got the wrong packet.
How we digress.
I do have the right packet, so let me clarify. You're absolutely correct, but we have to clarify that. And we're really talking about updating the zoning code and clarifying the criteria that the BZA should consider when determining whether there is a practical difficulty related to a variance. We have in our zoning code, we have a list of criteria that the BZA must follow, and an applicant must meet all of that criteria before the BZA can grant a variance. In a relatively recent Supreme Court ruling, Duncan versus Village of Middlefield, this is Ohio Supreme Court ruling, they clarified and better defined what a practical difficulty is, and they came up with seven factors that the BZA must consider. It's not an absolute, because it is in reality difficult, and it's not always black and white. So the court said, here at a minimum are the seven factors that the BZA should consider and weigh when they're considering an application for variance. What the Planning Commission approved for recommendation to you at their February 14th meeting is an ordinance that takes that seven criteria, also includes a couple, most of them overlap with what the criteria are in our current zoning code. I think there are two or three that don't overlap, and so as part of a full package of consideration, maybe it's 10 or 11 factors now that we're recommending total that should be considered by the BZA in determining whether a practical difficulty exists for an applicant to get granted a variance. And so staff and the Planning Commission are recommending to you and council that you pass these changes to comply with the Supreme Court and give better guidance to the BZA when they're considering those applications. We are not requesting a emergency, and since this is a change to the zoning code, I believe you had a public hearing on this the other day, and so it follows that normal zoning amendment process. I will say Grant Kerber, City Law Director, is here. He's the one who's drafted this for us, if you have any more legal, technical questions.
So this is not just for the overlay, it's for the entire city of Troy.
This is the BZA process as it occurs citywide.
Is there anything, a few years ago, there was a property, we had some property in downtown that was rezoned to R5, and the BZA overturned that. It was on Ray Street. It was on Ray Street, and they allowed multiple families to go into a house that was zoned R5. And the BZA, I believe, said you couldn't do that.
Did
Is
that have
that in
something
here?
to do with a group home?
No, I think that had.
Come on up.
I think that case was talking about a grandfathering clause that was lost that the BZA allowed to be restored. I believe that was a 400 block of West Ray Street.
That was quite a while.
Yeah, I would say that's about
That
maybe
was a
5
few
years
I'm
ago.
just wondering if this outlines that or limits the BZA in any way from having other houses overturned?
I think that was an overturning of the interpretation.
Yeah, that was not a
portion.
variance request.
Yeah.
That was an administrative appeal of
Okay.
the interpretation of the code. So that's different. That's not a practical difficulty determination. That's an interpretation.
And I think Mr. Livingston at the time was the law director, and as I recall, that's what happened. Mr. Seaver, do you have any questions?
No, I think it's appropriate.
Okay. Mr. Phillips?
Yeah, and I was trying to really coherently formulate them while we were discussing here, but in some of this practical difficulty, and when the property owner does not know a particular, if they purchase a property and they do not know that a particular thing may be out of ordinance, they're not automatically grandfathered into a legal status, are they?
No, they're not.
Depending on-
They're not at all, because you cannot create your own practical difficulty in the first place.
Well, I mean, a previous
And so-
owner, and somebody buys it, and then there's a condition
Well,
of
and if they
illegality.
continue to use the property and it was legally non-conforming prior to them, then that falls under the legal non-conforming section of the zoning code, and so there is no issue. The issue comes up with variances is when somebody applies for a permit to make some changes or to use a property in a different way, and we tell them before they do anything, before they act, no, you can't do this because of this, and they decide, no, we think we need a variance, and they can apply. Or too often, what happens is they'll build a structure, for example, they'll build it too close to the property line or over the property line, and then they'll come back and basically try to beg for forgiveness. And so they'll have to file an application, we'll deny it, and then they can file for a variance request. That's when those kind of things happen. When somebody purchases a property, there's an existing use that's legally non-conforming, this doesn't come into play.
But this applies to everything. If we start on the outside of the property and work inward, we'll say with a fence or with a garage, a workshop,
Shed, a garage,
shed,
a deck, anything that they do,
a
correct.
pool.
And it's also a pool as well as uses. If they want to change uses and they can't, and they want to argue that they need a variance. Now, typically, when there are use denials, they're probably going to ask for an administrative appeal that, no, they think that this use is similar enough to what's been going on now. But in rare occasions, it can be a use variance request.
Does the Home Builders Association, do they get notified of these types of changes?
Not as a...
Not as a matter of course?
No. No, I mean, everybody does as part of the process for making any zoning changes. So it goes in the advertising, and because it's a citywide, it does not get sent directly to a certain number of folks. It's a general advertising announcement.
Good, thank you.
All this is just giving a list of factors that their BZA has to weigh, right?
Yes.
And I mean, it'd be just like a series, Grant's out in the audience. It's just like a series of statutory factors that a court would weigh, right? That's what they're doing. These are the factors, and so when they make their decision, they're gonna have to go through each one of these factors and apply them to the applicant.
That is absolutely correct.
Okay.
Yeah, I mean, the BZA, it just says that when you're considering this variance request, you have to have some sort of factors to base your decision upon.
Right, and these factors were compiled by you, or these came out of that decision?
The great bulk of them came out of the decision, but they've also said that you can consider other factors as well, and I think the staff and the planning commission put together like a few other factors that enhance it, but, you know, since you're weighing it, it's not, you know, if you don't satisfy one of those additional ones, that doesn't automatically kill a variance request.
Right.
And so, just to clarify that, there are 12 in the proposed ordinance. 7 of them specifically came from the Supreme
The
Court
decision.
case. The other 5, where there was not overlap, because I think we had 7 or 9 of them before, the 5 are what we already had. So we're not proposing new ones, we just kind of blended both together.
You know, any guidance you can get from the court, that's what we need to do.
Anybody else have any comments or questions? Mr. Phillips?
Move forward.
I would move forward.
Let's move forward. Anything else to come before law and ordinance? We are